Hi, everybody, and welcome today as we discuss a topic that maybe is not very exciting, or actually it's kind of exciting, but maybe not very happy. It's a little bit more depressing, but hey, we're in 2020, so how much more depressing can it get? And the subject is trust in estates, and the message is why it is so important for you to do estate planning, regardless of the size of your estate, whether or not you have children. And I feel like we've seen in this year, 2020, the surprises it has brought, an unfortunate loss of lives that we've suffered abruptly, how important estate planning is, and also deciding what happens to you if, God forbid, you get sick. So today I have my dear friend joining us, Afshin Asher, if we're speaking in English, Asher, Persian, who is an trust and estates expert. Welcome, Afshin. Thank you so much for joining us today. I know you have a lot going on, so I really do appreciate the time that you're putting to come and join us and give us this information today. Welcome.
My pleasure. Thank you for having me. This is exciting.
I'd
rather be broadcasting from where you're at than where I am at right now, but I guess we can't have everything.
This gives us the opportunity to, kind of vicariously have everybody be a little bit in Hawaii and appreciate the Kauai vibe and the aloha vibe,
Vicariously, exactly.
Exactly. Well, I'm sending good vibes to everybody. But, earlier this year when everything happened with the pandemic, I actually had a flood of my clients call me because a lot of individuals really hadn't done any type of estate planning. And it's kind of one of those things that it's not fun to think about. Obviously, you're thinking about the worst case scenario. And it involves a lot of very, very difficult decisions, whether it's how you want to divide your assets, whether it's if you have children, who's going to be taking care of them if, God forbid, something happens to both parents. If something happens to you, what happens if you cannot make a decision? Who is going to be able to play the role of making those decisions for you? But with what happened this year, it kind of is a reminder of how delicate life is, how quickly things can change, how quickly illnesses can change. And the last thing you want to think about when you are in a situation where you or your loved one is very ill is, okay, now what do we do with all of these difficult decisions to make? So I guess the first question I want to address, or the first issue I want to address, is can you just go over the importance of why we need to have some sort of estate planning mechanism in place, and maybe the different options that are available? And the one question, which is what we always get, is, well, why do I need a trust? Why can't I just have a will? What's the difference between a will and a trust? And what happens if I have neither and something happens to me? That's a lot, but I'm going to let you just take it from there.
Okay, I'll try to remember all those questions.
Don't worry, I have it in here. I'll come back.
Okay. Somebody has it up there. The simplest way I wish I could describe why it's important to do estate planning is if I could have all of my prospective clients see what happens when something happens and there is no estate planning. The conflict that arises sometimes between family members, the tax issues, the court issues, the property titling issues, lending issues. And it's so easy. Well, sometimes it's not so easy. Sometimes it's complicated, but it is always easier to address these things and decide for yourself than let your family and loved ones have to deal with it themselves. So it really, at the forefront, estate planning is to protect your loved ones, because you don't want them to have to figure out how to proceed. You don't want them to have to be tied up in court for a year and a half. You don't want them to have disputes between each other. And if possible, you don't want them to pay avoidable taxes. So we try to minimize all those hassles and make it as easy for family members as possible. And so if you think about it as a gift, I actually think that when you do estate planning, it is the greatest gift you can give to your loved ones, because you're saving them a lot of hassles. Hopefully they don't receive that gift for a long, long time, but it doesn't hurt to have it in place whenever the time comes, for sure.
That's such a good point. And I guess a lot of people don't really think about that. So you mentioned, avoidable taxes and what could happen or what that process could look like. Can you explain to us, first the difference between a will and the difference between a trust, and what it would look like if one is in place versus another, I guess. Because I feel like a lot of people hear it and they hear the importance of it, but I don't think they understand the very real tax implications it might have, the cost implications, the time implications, if you, depending on which one you choose.
Absolutely. And in fact, what I'll do is I'll add another component of what happens if you do nothing. So we'll look at nothing, a will and a trust. And as an example, I'll talk about an actual case I had a couple of months ago. And this involved a grandmother who lived with her granddaughter for many years. The granddaughter took very good care of her and provided for all her needs. And it was also good for the granddaughter because she had a place to live. Her and her family lived with her grandmother. And it was always understood, I don't know how that was understood, but it was understood that when she passes away, the house would go to her granddaughter who's been taking care of her and living there. Well, unfortunately, she died unexpectedly and she had done nothing.
Oh, wow.
Had done nothing, and they met with me, and the question was, okay, what's going to happen now? How can I continue to live in the house? I said, well, when there's nothing done, there's no will, there's no trust, no estate planning whatsoever, then the assets are distributed according to California law. I live in California, I work in California, but if it was another state, it would be their local laws. And essentially, they're very similar. And when a person dies without any estate plan, their assets go to their next of kin. So for most people, their next of kin is their children equally. So all the assets go to the children equally. Well, that wasn't what was intended here. It was intended for the assets to go to the grandchild, but I just said that no, it has to go to all the children equally. So no problem. I'm sure everybody understands you've been living with grandma and taking care of her and she wanted you to get the house. I'm sure they understand. So let's meet. And we did meet. We had a family meeting with all the children. And guess what? A few of them didn't agree with that. They were looking forward to getting their inheritance. So needless to say, they're already selling the house and that granddaughter is shuffling, trying to find a place to live. And we all know that that wasn't grandma's intent, but because there was no plan in place, we went according to California law. Now, if she had written a will, she could have specified that she wanted that house to go to granddaughter. So that is the difference. When you have nothing, you go according to California law, but when you write a will, you can specify who's to receive your assets. So that would have saved a lot of the grief if she had simply written a will saying that I leave my house to my granddaughter, but not to me. Now, if she had written the will, the thing to understand is that with the will, the assets or the house would stay in her name. And when she passed away, we would have to go through a process called probate. And these are court proceedings where when a person passes away, a judge will transfer the deceased person's assets from the deceased person to whoever's named in the will. And as you can imagine, a judge isn't just about to sign documents willy-nilly. They make us go through a whole process. They want to make sure that all the debts are paid, all the taxes are paid, all the families notified. Heck, we even have to put an ad in the newspaper to make sure there's nobody out there that has a claim. And once we go through that entire process, which in LA County takes about 1.5 years nowadays, then and only then would the judge transfer the property to the granddaughter. So now we see, if she had done nothing, it goes to the next of kin. If she writes a will, she can specify who receives the assets, but those assets still go through probate.
In between, I don't want to interrupt you, but in between while that 1.5 years is going on, would the granddaughter, hypothetically in this situation, be able to continue to live there until everything is taken care of through the court system? Or is there a scenario where she would still have to move? Had the grandmother had a will?
It depends. It depends on if they're able to continue to pay the mortgage or not. If she's the only beneficiary, sometimes there are multiple beneficiaries, so the other beneficiaries expect to get paid rent for living there. But in a lot of times, she would have still been able to live there.
Okay, got it.
So it would have definitely been better to have a will than nothing at all. So now if you get to the trust, with a trust is very much like a will. It's an expression of wishes as to what happens with assets. But the major difference is that we take an additional step of retitling assets out of that person's name to the name of the trust. It doesn't really change anything. It's still that person's assets. They can do with it whatever they want. But by virtue of the fact that those assets are in the trust, they no longer go through probate because the judge doesn't have to transfer a deceased person's assets to someone else. The trust, the name of the trust still exists, and somebody else manages the trust and transfers it. So with the trust, we're able to both handle the testamentary wishes of the person about who receives their assets, but by transferring the assets to the name of the trust, we're also able to avoid probate.
So it's definitely the best option out of the three, in the sense that you're avoiding because time does matter. I mean, sometimes we don't realize that like a year and a half with assets in the air, especially, I mean, again, this year has shown us so many things, but what if you actually need them and you can't do anything with it? And it, I mean, it's just, it seems like it's such an, I mean, it's not necessarily an easy step to take. It might be a little bit daunting at the time, but long-term, certainly it is. And because you can completely, obviously, if there's no one contesting anything, you can completely avoid the court system, correct?
Completely avoid the court system. And I honestly don't think it would be that daunting for most families. On occasion, I see families who struggle with their choices, but in most instances, people know what they want. So let's just say it.
It's one of those things. I mean, my personal experience, I've known you for years and I keep saying, oh, I want to all, and I did it before any of this happened, but I kept saying, you know, Afshin, I have to come in and talk to you. I have to come in and talk to you. I have to come in and talk to you. But there's like this part of me that felt, well, like, I don't really have kids. I don't this and that, but it really wasn't until I think we went to lunch one day and you were kind of discussing things not necessarily related to me. And I was like, well, you know what, this is kind of irresponsible, because basically it was honestly one of the easiest things I'd ever done. I mean, obviously you're my friend, so it was a fun interaction. We went and had lunch and we filled out the form, and it was, you know, and there were some difficult questions in terms of, okay, well, what happens if, you know, I get sick and I'm unable to make decisions on my own, or who do I want to be? I mean, the beneficiary part, I think, is easy for a lot of people. It's more of like, well, who do I trust to put in charge of it? But those are important questions to ask. And I don't know, for me, it was a very liberating thing, because I felt like, I don't know, I felt like I was comfortable, because I knew if something, God forbid, were to happen to me, who I want to make sure is continue to be taken care of, I can take care of that. You know, who I want to get what will get it. And then also, I think, again, what we've seen this year is if something out of the blue happens to me and I'm unable to make decisions, I actually went through the process of talking to who I want to make those decisions on my behalf, make sure that person's comfortable with it, make sure that person knows and understands what I want, you know, and it was very good. And it was, honestly, it wasn't that, I mean, mine isn't that complicated in the sense that it's not like I had so many assets, and it's not like I had all these, you know, like kids or whatever. Still, it was peace of mind, and it was, but I can't imagine it being that much more difficult, because it wasn't, I mean, imagine, well, because you just kind of put everything in there. And from my understanding is, you know, hopefully as I continue to acquire more assets over time, you just add it in there, correct? Like if I purchase something, maybe a house in Hawaii, yes. I can just do that, right?
Just give them the trust name, and instead of your name, you acquired in Hawaii, and invite your friends over who wrote the trust in the first place. Let's do a Zoom,
you know, from here. You know, if the inner island quarantine had been lifted, if the island quarantine had been lifted, period, I would have had you here so we could have talked about this.
Sounds good.
So one of the things I thought, when the reason I kind of didn't do it, is because I always felt like you needed to have like a minimum amount of assets before you planned. Can you address that? Is there a minimum before one does estate planning, or goes and gets a trust, or makes a trust, or develops a trust? Is there such thing as that, or not?
Well, no, not really. As us lawyers always say, it depends. So first of all, if you have minor children, it really doesn't matter how much you have. You don't want to put your minor children who are legally incapable of managing assets in a predicament where they're stuck. So you could have $200,000 or $2 million or $20 million. You want to leave it to your children and they're minors, you need to have something in place because they're not capable of legally managing assets.
What happens if someone, like, let's say there's a couple and they have a young child and they have, let's say, $500,000 in a house, and something happens to them? What happens in that scenario? Like, and they have nothing in place. They have no mechanism in place.
It's a pain in the neck. So we have the probate I just discussed, but then we have to take an additional step of having a guardian appointed over those assets. And that guardian has to report to the court periodically and talk about what's been transpiring with those assets, post the bond, essentially insurance for managing those assets. So it just is a continuing.
Who gets, what is there a process in place for in terms of how and who gets appointed to be guardian?
A lot of it is who goes to court and tries to seek the appointment. But then if there are different people who want to seek that appointment, then it becomes up to the judge essentially. And again, it becomes a mess. So another factor, putting assets aside, is that when you draft a will, it's an opportunity for you to decide who has both legal custody over your children, but also over their assets, so that it can be managed as effectively as possible until they're adults.
I can think of about 8 couples that I know that are in this situation that I described. And it's, to me, the scariest thing is to not have a say in terms of who, and because just as you described in the situation of the grandmother, maybe they might have informally amongst themselves said, well, if, you know, I haven't done this, but if something happens to me, you do this, right? But in that moment, that's not legal. There's no legal requirement for that to occur. So if 3 other people show up in court and say, no, I think I can do a better job, you're leaving it up to the judge to chant. I mean, what your wishes are not going to be 100% fulfilled after you're gone, unless you take the step of putting it down on paper. What about the estate tax exemption that exists? And a lot of people feel like if they have less, so I think you earlier this year when we discussed it, I think you had said that the tax exemption is 11.5 million. And so people think, well, if I don't have that, that much in assets, then I don't need to do anything. And for all these reasons, I think that we've discussed, that may not be true, correct?
Absolutely. So it's a common misconception that if they don't have an estate tax problem, that means that they don't have any legal issues. But that is not the case. If your assets are in excess of $150,000 in California, for example, your assets could go through probate if you don't have some kind of an estate plan in place, such as a trust or beneficiary designation. Even with a will, it could go through probate. So probate and the legal hassles and delay associated with that have nothing to do with estate taxes. Estate taxes are a federal tax and is a byproduct of your net worth. But for most families, estate planning is important to protect your children from costs and delays and hassles. And they don't have to necessarily worry about estate taxes. Some families do, but not all.
So I'm trying to remember the areas that would be covered. So it's obviously what happens to your assets. If you have kids, what happens to your kids, and then decisions regarding yourself if you're unable to make decisions, correct? Can you go through that part of it? So what are the type of decisions that you have to make about, you know, if you become ill and you can't make decisions, what are the types of questions that they need to answer, or decisions that they need to make in that regard before they can, in order to complete this process, I guess is a better way of saying it.
Sure. When people think about estate planning, they're most commonly thinking about what happens to their assets when they die.
Correct.
But especially with today's medical technology, people are living a lot longer, but sometimes they no longer lack the capacity, no longer possess the capacity to manage their assets or make medical decisions for themselves. So in addition to death planning, we also tackle another unpleasant topic, and that is incapacity planning. What happens if you're alive, but you're unable to manage? So we usually deal with that by creating financial powers of attorney, which specifies who can sign on your behalf if you're alive but incapacitated, so that they can sign your tax returns. They can deal with the insurance companies. If you're in the middle of a refinancing, they can finish the refinancing. They can go to the post office on your behalf. Anything that comes up, make IRA designations about how to manage those assets. Anything that comes up, things that you have to deal with on a daily basis. If you're not able to do it, your spouse is legally not permitted to sign on your behalf. That's a misconception out there that I'm married and my spouse will just sign for me. That's not legal. you have to have a financial power of attorney or a durable power of attorney in place, authorizing someone to be able to act on your behalf and sign on your behalf. On the flip side, you also have to determine who can make medical decisions for you if you're unable to make it. Sometimes the hospitals will allow your closest family members to make the decisions for you. So sometimes things go by okay, but it's better to have the individual you want to be making those decisions appointed instead of having the family to fight it out to decide who makes those decisions.
Well, and also tell them what it is that you want, so they don't have to live with this guilt if they make a certain decision, or, you know, or if, because I mean, I don't want to obviously get into the not so pleasant aspects of it, but it's very unfair to have a situation where you're basically putting your loved ones, you know, in the position of making very, very difficult decisions regarding your health, whereas it's always going to be a difficult decision, but if, at least there's the comfort of knowing that it's what you wanted, you know? So I think that was very, that was one of the hardest things I kind of struggled with. Not necessarily, first of all, I think about it myself, and I had to actually talk to some of my friends who are a little bit more, you know, aware of the options that are available, or what the scenarios could look like in various scenarios in the medical field. And then, you know, I talked to someone who I wanted to make that decision, who I knew could and would be comfortable, or as comfortable as one could be. and it was, so that was that was pretty important. And then I have two.
Let me interject one aspect of the healthcare directives. One of the most important questions we ask people is that if, God forbid, you're in terrible shape and you're unable to stay alive without the artificial life support or things like that, would you want to be kept alive if two doctors believe that there's no reasonable hope to get better? And the reason why this is so important, as you pointed out, is that whoever you put in charge to make that decision, they will feel guilty no matter what they do. If they keep you alive on life support, they feel guilty that they're torturing you somehow. And if they pull the plug, they feel guilty that they're killing you. Why put that on anybody else? Express your wishes. What would you want them to do? Take that burden off their shoulders, as you said. Again, it's the greatest gift you can give your loved ones.
Absolutely, and I feel like I really hope that that's the takeaway from this for a lot of people, is that there is this misconception of estate planning is only for those that are super wealthy with tons of assets who don't know what to do with it. And that's just not true. All of us need to do it. And, you know, depending on what you have, or, you know, that might make the process easier, but it doesn't make it any more or less important, because there's so many different sides to it. And I keep repeating it, but I'll just say for the last time, hopefully, is that, you know, this life is fragile and delicate. And this year has been a clear indication of how unpredictable it can be. So please do. I mean, there are so many people that I know that still haven't done it, and it blows my mind. And there's people with children, and that's really, really what blows my mind, because I mean, what is going to happen to those kids? Like, and the other question I have is, what if you're separated, or what if you're divorced and you share kids? So what happens in that? I mean, do the kids automatically go? Do you have a say in terms of where the kids can go? Is there any way to limit like, for example, if you have 50% custody, to say, well, I want my kids to have my 50% of time with, like, for example, my sister or my grandparent or this person or that person. Can you do that? Or is it automatically, if their other parent is alive, do the kids completely, the custody gets shifted to that parent?
In California, at least, almost always the surviving parent holds most of the cards. There are exceptions. There are sometimes, as part of the divorce, a parent has completely given up custody. There are times where there are documented reasons why a parent should not have access or a custody over a child. But in most instances, the other parent will get the kids. But at least you can specify that you would want your family to have regular visitation rights and things like that. Give them some rights to try to, you know, keep the connection with those children.
Okay.
So and I always say it's tough when you get divorced. You're still connected because of children when you have children. And so the one facet is that if you want to specify guardians for your children, and your spouse or ex-spouse does estate planning and also specifies guardians for the children and their different guardians, then there could potentially be conflict. So that is one instance where it would be helpful if both parents get together and try to come to a resolution as to who would be the guardians if something happened to both parents. And
I have a list of people I'm calling after this, after our little interview here, because there's so many people that are coming to mind. I don't think that they've done any of this, especially
it's easier said than done. And I've had some clients say that, well, my spouse will probably never write a will, so I'm the only one writing a will, so that'll stick, but you don't know what will happen. So if at all, you should try to come together and come to a resolution on that. And it's easier said than done. I totally get it.
So I know we have only a couple minutes left, so I'm going to ask you one last question because it's been a big one that we're getting. And it's obviously a lot of people are going through financial difficulties. A lot of individuals are in situations, whether they're in lease agreements, mortgages, or they have issues that are developing with creditors because they're unable to meet their obligations because of the financial difficulties as a result of the pandemic. And I think that there is this belief that if I move my assets to a trust, it's going to protect me from creditors. Or if I move it to this person's name, it's going to protect me from creditors. Or if I get a divorce from my spouse on paper, and then I put everything in the spouse's name, or what, vice versa, or something, it can protect us from creditors. Is any of that true? Is there really any mechanism that would be able to protect an asset from creditors, or has the law really looked into all of these various scenarios and accounted for them?
At least in California, for the most part, all those loopholes are closed. So certainly, as you said, a lot of my clients also had that misconception that they can just create a trust, put their assets into it, and somehow it's protected. That's absolutely not the case. You can transfer assets to other people with the hope that that protects you, but California and most states have something called fraudulent conveyance laws, which say that when a person transfers assets to another person and is left unable to meet their financial obligations, if that can be proven by the creditor, those transfers can be reversed back. So obviously the idea being that you can't just have debts, then transfer all your assets to someone else and say, hey, I don't have anything, so I'm not going to be able to pay it. So it's not necessarily easy for a creditor to prove a fraudulent conveyance, but it's definitely possible. And they can also get attorney's fees when they pursue that. So I caution everyone about making transfers to third parties before conferring with an attorney to see if this is really a feasible solution. However, I should point out that whoever has any type of a ERISA qualified retirement plan, like a 401k, a defined benefit plan, a defined contribution plan, those accounts are 100% protected. So if you're able to contribute to those types of accounts, and it's part of an employer plan where there are other participants, that's a great way to get it protected. An example we always give is O.J. Simpson, who had an NFL pension, and he was, lost the civil case, but still no one could touch his NFL pension. So for people who are concerned about liabilities and have the capability of still contributing to a 401k or something like that, I think they should consider that.
Great. Well, thank you so much, Afshin John. We're gonna put your firm information in the caption for where we list this, and we'll have it on our various social media outlets so that if people have other questions, they can get in touch with you directly. Thank you so much for your time.
My pleasure. It was great to see you.
This year, and we were asked for it back by popular demand. It was great to see you as well. I'm sending you lots of aloha.
I'm going to get airline tickets. I'm coming over right away. So.
Well, I am actually exploring, taking the Hawaii bar and learning about trust and estates here. So, but is there overlap between, I'm just curious, is there a lot of overlap between various states, not specifically Hawaii, from your experience?
Well, certainly the federal estate tax laws are federal, they're national, and the concept of probate and wills and trusts are all going to be the same. So, it may be a little different, easier or harder, depending.
But you're still going to have to come here to help me figure out what to do is what
I'm basically. Sounds good. I'm already picking out the beach. So.
Well, thank you so much. I hope you have a great evening. Please stay safe, and looking forward to speaking to you soon. Take care.
Take care.
Thank you.
Bye.
let me figure out how to stop this.